CPL Quiz 8, questions 1 through 4 and questions 28 through 37. So question 1. As the term youth is defined in Article 720, a youth is, and the answer is B, a person charged with a crime, and a person at least 16 and less than 19 years old, so that includes 16-year-olds, 17-year-olds, and 18-year-olds. Question 2. Eligible youth means a youth who has not, and the answer is A, all of them, and so it's 1, been convicted of a Class A or A1 or A2 felony, 2, been convicted of an armed felony with no mitigating circumstances, 3, been previously convicted and sentenced for a felony, and 4, been previously adjudicated a youthful offender after being convicted of a felony. Question 3. A youthful offender adjudication consists of, and the answer is C, 1 and 2, but not 3 and 4. And so 1 and 2 are a youthful offender finding and the youthful offender sentence. Question 4. A youthful offender adjudication is, and the answer is B, 1, 2, and 3, but not 4. And the 3 are not a judgment of conviction, does not operate as a disqualification to hold public office, and does not operate as a disqualification for public employment. Okay, so on to question 27. 28. When a youthful offender or his or her agent wish to obtain the youthful offender records, such request may only be made to, and it's to the court or the clerk of the court where the records and papers are on file. Question 29. In general, hospital confinement under an order of examination shall not exceed, and the answer is B, 30 days. Question 30. An indictment filed in Superior Court against a defendant for the crime charged in a felony complaint is not timely for the purposes of CPL 730.40, subsection 5, if it is filed more than blank after the expiration of the period prescribed in a temporary order of observation issued by a local criminal court where such felony complaint was pending, and the answer is D, 6 months. Question 31. When the court issues an order pursuant to CPL 730.20 and hospital confinement of a defendant is necessary to comply with said order, such confinement shall not exceed a period of blank days except upon application of the director. The court may authorize confinement for an additional period not exceeding blank days if it is satisfied that a longer period is necessary. And so the answer for both is 30 days. Question 32. When does the court determine whether an eligible youth is a youthful offender? And the answer is C, at the time of pronouncing sentence. Question 33. When a youth part directs that an action or charge is to be removed to the family court, the youth part must issue a blank, and it must be signed by blank. And so the answers to that is an order of removal, and it has to be signed by the youth part judge. Okay. Question 34. Upon the blank of an order of removal in a criminal court, the criminal action upon which the order is based shall be, and the answer is C. So it's upon the filing of an order of removal in a criminal court, the criminal action upon which the order is based shall be terminated. Question 35, is it true or false? After the family court assumes jurisdiction following an order of removal, all further proceedings shall be in accordance with the laws appertaining to family court, and for this purpose all findings, determinations, verdicts, and orders other than the order of removal shall be deemed to have been made by the family court. And that is true. Question 36. When an action is removed pursuant to numbers 34 and 35, the questions we just did, the court that directed the removal must cause certain records to be filed with the county clerk outside of New York City, and within New York City with the clerk of the blank. And that is the Supreme Court. So again, let me read that to make sure that you understand it. So when an action is removed pursuant to questions 34 and 35, the court that directed the removal must cause certain records to be filed with the county clerk outside of New York City, and within New York City with the clerk of the Supreme Court. And there's little asterisks here that say, please read CPL 725.20 subsection 3 about the clerk's duties very carefully. So make sure to do that. Next question, 37. When a local criminal court accusatory instrument other than a felony complaint has been filed against the defendant and the court is satisfied that the defendant is an incapacitated person, such court must issue a blank order of blank, and it's a final order of observation. So again, when a local criminal court accusatory instrument other than a felony complaint has been filed against a defendant and the court is satisfied that that defendant is an incapacitated person, such court must issue a final order of observation. And I believe that is it. So everybody, good luck.